Good morning, everybody. It's Bella. I have Ello of Lana here. I'm gonna put her on speakerphone to say good morning. We're doing this stream a little different. Hold on. Hello? One sec. All right, here she is. Say it, Ello. Don't scream, Lana. Go ahead. Yeah, you're on.
Good morning. We're just testing this out. I'm not going to be on through this way, but I'll be on through a different way. But good morning. I just wanted to say, bubbly bitches. Shake it. I gotta get my oil changed. I didn't even know get my oil changed. One morning already. Somebody ran over a duck in front of me and
Don't say that. That's horrible. It's not even 6 a.m.
They did, and they were trying to give this duck CPR or something. I didn't want to help, and I was like, I gotta go. I'm so sorry. I don't give a duck right now. Right?
Okay, they can barely hear you well. But yeah, that sucks.
I'll be there in a second.
Okay. She'll be with you guys in a sec. So we're going to be starting the stream. They're going to be starting it in about 6 minutes. I think everyone does it in 6 minutes. Starts their stuff in 6 minutes. I think that's just life. So we'll be right back with you. We're just making sure you guys could hear us. Okay, wait, I have to mute so you don't do weird stuff. Okay.
Good morning. Oh my God. Two Lanas. Yeah. So, just a couple issues. My modem is what happened. My modem blew up. And the speed has never been an issue for Lana. And clearly it's still not. So, they said I had the legacy plan, but they didn't realize when WoW was bought by Breezeline, I still had all my WoW equipment. So they had to fire me on over a brand new I wanted all the works. So that was the issue. That's what was causing my lags. So just if anybody want to know. Now, let's see if we got this down. Again, good morning, everybody. No joke, somebody just hit a duck. Like, I was driving behind somebody that just hit a duck. Trying to give ducks mouth to mouth. Asking for my help. I said, I'm sorry, but I have no ducks to give. So I gotta go. Okay. Okay. Can you guys all hear good? Okay, perfect. Now we're going to have like 3 devices going, and we're going to have the trial. Everything's going to be perfect. Let's talk about Randy. How about Randy? Rescue Randy, man. Okay, let's see if I can do this even better. If anybody can't get a date, I'm sure Rescue Randy is available. Rescue Randy. Don't you guys hate it when you wake up in the morning and you ask yourself, oh my God, did I take those pills? Did I take my Flonase, my Zyrtec? And then you're just like, fuck it, I guess I'll take it again. And even if I did, I guess I'm taking double. I mean, am I getting too old that I need to start putting my medicine in little containers instead of Monday? My allergies this spring have been crazy. Anybody else have that issue? Yeah, I'm just doing lines over here. Hold on. Yeah, so perfect. Next thing you know, the cops are gonna show up. All the trolls. Okay. Let's see if I can do this really special. Okay. All right, good morning. Yep, that's Atlanta. You need day containers. Fun fact. Rescue Annie and Rescue Randy, named by their inventors, who created them after his daughter. Oh my God, because nobody knew how to do CPR. That's actually horrible. Hit that thumbs up. Look at guys. Everything looks so perfect today. You know, we're just rolling on all cylinders. Love it. Let's take a look at something though. Let's do a little Karen Reed recap here. How do we feel? Do we feel like Karen Reed is gonna, like, you know, we feel like good hands with Allstate? She's got this all day. She's got this all day, every day. Or is Canton confidential? Did Kelly Dever change her story after meeting with police commissioner? I think so.
All right, let's head back to the courthouse here behind me in Dedham, Massachusetts, where it was day 25 in the Karen Reed murder retrial, where they got heated in the court with the former Canton police officer, Kelly Dever. Earlier today, she was questioned about a meeting with the police commissioner during the initial investigation into Officer John O'Keefe's death. Let's watch.
Did you tell those law enforcement agents on August 9th, 2023, that you saw Brian Higgins and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Okay. Ms. Dever, when we left off, I was asking you about the meeting at the...
You guys, how do you recollect that at the time and then realize that, oh my God, that wasn't my memory, that was somebody else's? Because I watched all these media outlets, then I thought it was my memory. Well, be prepared to hear stuff like that in the Brian Kohlberger case, because that's coming with Bethany and Dylan. 1000%. Ooh. Oh my God, we have a fan that's moving normal. Oh, hell yeah. You guys check out that fan, bitch. You guys.
I just died hearing you say that. What? That's like the best thing that's happened all week. The moving fan, it's right on time. Hello? Are we not gonna be able to talk together? You better talk at the same time. Hold up. Now I'm going to have to mute. Don't be serious. Like, did that seriously like knock you off? Okay, you're muted. Oh my god, do I have the ability to mute you, Elo? Okay, no. Lana, seriously, don't mute right now. We gotta check this out before the trial starts. I'll mute, see if you can talk. Go out and come back in, Elo, if it's not working. It's kind of hilarious. Just leave and come back in. Hi, everybody. How are you guys doing? We got a moving fan, moving at the right time. She wasn't wrong about Diva or Dever. At least they said my name right. The commissioner said my name right, Mr. Jackson. She's back. Hi, guys. There she is. And I'm mute. But I think you're Are you lagging?
Am I lagging?
No, you're good. Can we get rid of the Lana Oriani one?
Yeah, I could probably do a lot of things special. Let's see. There you
go. Okay. There we go. 3 Lanas.
It's been a morning.
Top of the morning to you.
Is it
Dever?
It's all good, right? No echo. I just want to stare at this fan for a minute, make sure it's like, as long as it keeps going like this, we're golden. These are our brain powers working together here. So I'll give a morning shake for Bella. She got up super early.
Yeah, it's not even 6 a.m. here yet. The birds are just waking up.
Yep.
It's good. It's all good. Love to be here with you guys so early in the morning.
I think we should start off bingo with a bang.
Bingo with a bang. Okay. Yeah. What do you want to
do? I want to do a +1. Like you have to have bingo +1 square touching your bingo. We'll call it Rescue Randy.
When you call it touching the bingo, do you mean touching?
Like your bingo, like your little line. Like
your little line.
Okay. Yeah, one of your squares have to be touching. Like a random square that you have on the board that you hit on has to be touching your bingo.
Okay.
One of your bingo squares.
Oh, Karen, thank you so much, honey. Like it, Karen.
Karen gets a 10 Truth and Transparency memberships.
Always coming through.
As long as I see that fan just keep moving, I don't care if I get like cut out every now and again. As long as that fan just keeps, I've never been so excited to watch that fucker spin. I'm not even kidding.
Mm-hmm. You're a big fan of the OnlyFans?
I'm a big fan of the spinners.
Okay, that's a good thing about bingo. Let's do that with bingo. Everyone, one card.
Yes. So yeah, Murky's just been nailing it.
Yuri's
Yeah.
math teacher.
Where's Murky? She here? Murky's always helping out, doing the bingo boss.
Hey, the toolbox, Yuri. The toolbox is banging this week because it's Pride. So, the toolbox is going to have tons of people in and out of that bitch all week because it's Pride Week here in Columbus. At least I think. I think it starts off today and it goes all the way until Sunday. If I'm not mistaken, if I got my gay on. If I got my gator on. I know everybody thinks that I've like died or something. Let's just say I got a lot of emails about my live last night about the Idaho 4 case. I'm going to make you a believer. It's just a believer in the data until you find other like stuff that shows you that the data is not right, but my data isn't wrong. You know, just looks a little sketch. Oh, are we doing bingo? I'm going to have to get a new card. I lost mine. Yep, grabbed 27 of them. I'll make
Let
Bella
me get the link.
Yeah, I'll make Bella go do that.
Okay, let me do that. Be right back.
BRB. Now I'm a believer. Angie Burkhart looking fabulous this morning. She's talking about probably something wild and wacky and great. And we're over here just like, we just care about the fucking fan right now, man. Just spin, baby. Okay. I think people don't believe it. I think people are going to be like, yeah, Lana's going to be live for like 10 minutes and then just, well, not today, folks. Not today. TNT, your Idaho 4 timeline makes much more sense than Ellie's. I know. Their timeline is just whack. They're going to have so many problems. And all I know is if Brian Kober is the one, like, no wonder why they're doing all these hit pieces. But, man. Karen, I'm so excited. I just can't hide it. Me too. Me too. Happy Pride Month for my daughter. Yay. Yay. I'm going to go ahead and go downtown. I take Jax. We like to go people watching. No joke. I don't know. I don't know if you guys know this about me, but I used to live in Key West for a little bit. And I told him the only reason I ever left Key West is because of him, because of Jax. Because he wanted to raise Jax in, Key West schools can't be that great. Better school districts. But it's also Pride Month, obviously, is June. But Key West just had their yesterday, or what was it? Sunday, Saturday? They had their parade. And so in Key West, everyone just paints themselves. They don't wear shirts. And you just paint your tits, like with the pride flag colors and shit. And let's just say Lana didn't know this the first time Lana was in the Key West. And I'm like, oh my God, all these people are going to get arrested down here. No, actually, it's like you're the odd one if you don't do it. But God, do you know that Key West is the safest place in the United States of America? Crime-wise, there ain't no crime there. The worst that happens in Key West is you might get a bike theft. Okay, guys? Like, Key West literally is, go look it up, it's fact, the safest place to live in the United States of America.
Ella, can you pin that now? I put it up.
I'll pin you. What?
Yeah, it's so much easier to just tell you in chat like this.
Just pin you?
Pin it.
That's not appropriate language for everybody, Bella. Get with the times.
Pin that thing.
Pin that. All right, here we go. Get your bev on. Pin. All right, it's pinned. Can everybody see it? Yeah. Welcome back. So I believe this trial is starting as like anticipated for the Brian Kober case, but regardless, going to give you guys a heads up. I'm going to be in Pennsylvania on June 30th. June 30th, there's a hearing, I think. There's a hearing in Washington on June 25th. This has to do with witnesses. Can I get a witness? they have to show good cause why they cannot go and travel and blah, blah, blah. No one's going to be going in there saying dilly dick. But unless they close it down to the public, I'll be going to that. And then my travel schedule will be nuts. I'll be in Boise for the end of July for the Voire, and then there's like a little break. And then they go right into the trial on August 11th. So I thought they were starting the trial August 15th. So I had to rearrange all of my summer vacation plans with Jax. And Jax has a big surprise waiting for him. Super stoked for him. He's going to be able to do vacation and a soccer camp all in the same week. It's just like perfect for Lana too. So in the morning soccer camp, and then in the afternoon beach. So I think he's going to love it. Road trip to see Messi. I'm road tripping. We're going to go hit up the Cali beaches. And so he can go do one of the Barcelona soccer FC camps. He's going to lose his shit. He's going to be stoked. I'm not going to tell him that part, though. He's going to be surprised. He's going to think we're just going on regular vacay. And then, voila, we show up at the Huntington Sports Complex. He's going to be like, so. And Mama's going to love it because Mama gets like a vacay too. Okay. Like I drop off Jax at the soccer complex, at 8 a.m. Mama has her time to come live and just be wild with you guys for like an hour or two. And then Mama still gets some time. And then I pick up Jax and then we do all our afternoon stuff. And he's just going to be like, for the week. And then we watch fireworks explode. So that's the plan. But Jax doesn't have any clue, so don't tell him, okay? Shh, gotta keep it between us. You're gonna have to pack his cleats in your bag. Yeah. Actually, they give him a bunch of stuff. It's really cool. They give you like a whole kit. And it was so funny when I was talking to him about like going to camps. I was reading like, hey, this is what you get to do every day. Like they have different things. He's like, wow, this sounds really like, this got a lot of rules, Mom. Like it seems like it's got like, I have to like, I'm going to be told what to do the whole time. I'm like, what? I'm like, why are you thinking about that? I'm like, no, you like, look at you have to do this competition and then you have to do this skill competition. And then at this time, so it's like all like, and you want to know why he was thinking like that? Because it looks like it looks like how your school day is, like 8:15 to like 8:45. You're at this station, and then you move to this station, and you're doing this. And I was like, but guess who gets to like train you and teach you? It's people from the actual Barcelona like team, like people like from like their coaching staff, their developmental stuff. And but yeah, his first comment to me about one of the camps here was like, wow, that seems like it's really like a lot of rules, Mom. A lot of rules. I said, wow. I said, yeah. Camps were so much fun. I love camp. Oh my God, you better keep spinning, you bitch. Yes, I will share some pics. If that fan stops. You guys, look at that fan. Look at that fucking fan. Yeah, I'm going to blast it on the airways. I'm back, bitch. Trust me, if you guys like you were pissed or whatever, like how do you think I was over here? Like I literally was losing my shit. And then I had, I think maybe it was like God's way of sometimes telling you some stuff. I actually had a ton of stuff to do with some stuff that I was working on for my cases. And I literally was like, oh my God, maybe this is like a sign that my modem just blew up, because I was at the court. I was like at the courthouses, just like in and out, in and out. I filed a almost, what was it, 467 page motion. Over 300 pages. Like it was like, were all exhibits. Organizing that shit, you got to give it up to the paralegals. You got to give it up to the clerks that work at the law firms. Dude, when you're making multiple binders and you think like, oh, I just got this, like I'll just photocopy, and then it's still, you get one piece of paper out of place, your fucking whole binder's wrecked. And then you're looking through to see what the fuck you're missing to make it like whole again. They got to come up with a system. I need some secretaries over here. Oh, let me tell people that we're live and we're in charge again. Okay. I think Karen Reed, though, I mean, watching Rescue Randy get pulverized should show everybody, it should remind people that there would have been no clean bust out of her taillight as well. Like it was too clean, right? So that's what everybody should be. That's what I took away from Rescue Randy, is that let's not forget how not clean breaking stuff is. Okay. I was on Replay Crew last night live, and it was blah, blah, I sent cash. You sent cash? Who sent cash? Well, thank you so much. If anybody sent cash. Heaven forbid Bev starts on time. We don't need Bev starting on time because Lana needs to win her bets. You guys, it is day 29. Day 29. God, I have so many papers over here. Oh my God. This is why I don't. Because I'm a believer. Oh my God, what is it doing? Oh my God, what is that fan doing? What the fuck are you doing? Don't you stop. Don't you dare stop. Okay. Let's go back in my Brian Kohlberger files. What's going on here? Is everything... I don't ever get paper cuts. I'm a good not paper cutter person. Okay, back to the motherfucking basics. Let me tell you something though. Ready? Because of the Karen Reed case and because of Daddy Alessi, Lana nailed the fuck out of one of her arguments because of him. Dude, I don't know about you guys, but don't you like learn a lot from watching this shit? Like you learn, dude, my vocabulary has totally increased, like out of this world, right? But then I learned a bunch of stuff. So I'm over here and I'm like, oh my God, one of my objections is methodology. Like one of my main objections is methodology. So I don't know if Bella fell back asleep, but she can probably at least give me the backing on this. I was like, bells. I was like, oh my God. I was like, this guy did not show any of his methodology, and he is labeled as an expert. So and I just went ham on. I was like, oh my God, this is perfect. So the Karen Reed case has helped me. The Idaho 4 case and Taylor's filings Those are just money because they're trying to do everything and anything. So you've like learned little new gadgets all day. Oh, here we go. Oh my God, come on, Bev.
Was now open, you may be seated.
Hi, good morning.
Is it me?
So I just saw a transcript that was placed here on maybe reference this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right.
Is Beverly speed up?
So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this? Okay.
With regard to Dr. Crosby and Ms. Coons, as the court...
Speak into a microphone. Speak into a microphone.
With regard to Dr. Crosby and Ms. Coons, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony. All right. As it relates to Dr. Welcher, the scope of his testimony, our request is that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolf and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all, Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Lapisada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Lapisada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lapisada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor?
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Lapisada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that, but when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it, I know what I think, but it's the Commonwealth's motion.
I think that her opinion
Oh, what?
of no object.
See, that's the shit I'm talking about. That's biased.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the,
All right, I might have a different page 7.
I bet you did that.
So my page 7, okay. Okay, yep.
Dr. Lapisada proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
Left to argument.
So I told you that on Friday, Mr. Jackson. Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony, but basically she's not only done autopsies involving dog bites and the wound pattern recognition related to the source of those dog bites, she's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern wounds. She has a methodology that she uses. Medical school classes, I didn't mention the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't see any opinions unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you, okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of the jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability of education and experience. I can't do that if we call her and ask her for a jury or a voir dire.
But that's where, if we want to compare apples to apples, Dr. Wolf, Azig Wolf, was allowed to specifically testify to the wound pattern, or his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the report. We didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern recognition. At least in his mind, you can cross-examine on it. There is no requirement that the Commonwealth have every single case that Dr. Lapisada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it, but I have
So,
to entertain it.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that properly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Thousands, multiple thousands.
So,
But if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with Voire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on Voire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to introduce.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence. Yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the movement patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay,
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
Okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could.
And this, for point of clarification, if I ask her, would you expect, I'm just going to make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see a bruise or contusion?
What do you say about that?
I object. One, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lapisada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth versus Tompkins, appeals court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Lapisada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria to Daubert Lanigan. And so recently it's been found by at least another court that she's not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the article witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training experience.
I'm sorry, where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by a regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess for, which is another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
All right, sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's product. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
to do this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lapisada?
No, not
Through whom?
Yeah, can I do with regard to these photos, well, ultimately, the Lapisada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be took measurements from the street to the various entrances to 34 Fairview. I would just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a voting defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are, photos are introduced on that code mission to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Lapisada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all of these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and and then bootstrap it to Dr. Lapisada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay. So,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolf?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lapisada. All right, bring one over, please.
Testing. Oh my gosh. Is there any bad feedback? Three Lanas. No, it's good.
Were you not able to hear me that whole time?
Yeah, no, I had to do something. But at least I had to keep it kosher so that everything would be good with what I'm doing now. Okay. Whew, you guys. So the measurements are allowed in, but not the photographs, because Hank Brennan is basically saying that that's basically it's like Ann Taylor arguing about he says that they're overly prejudicial. Okay. Dude, you need to call Brian Jr. to the stand. If you call Brian Jr. to the stand, you just need to ask him if his garage had carpeting or was it hard floor? Did your garage have he has personal knowledge of that. And there's like no scope for Brennan to go like ham on cross with him. But if you call, or maybe they plan on calling Caitlin Albert, she has personal knowledge. But I just got wind, and I'm super excited. Derek Ellington is motherfucking testifying. Yes. Yes. And Hank Brennan does not want his new report in. Amazing. Amazing. I'm still able to be heard, right? Okay. Let's see. Yes. Loud and clear. Oh, God, this is amazing. Okay. So, where is it? The picture should totally be allowed in. Mr. Ellington. Commonwealth's motion to preclude new opinion testimony by defense expert Derek Ellington. On June 1st, 2025, the defense produced to the Commonwealth a new report from defense expert Derek Ellington. Derek Ellington is the phone. He's like the Murdoch phone guy, but he didn't do the Murdoch murder case, okay? But he's out of North Carolina. He's who I've talked about on this channel. I said he is going to be he's going to blow it all up. The new report appeared with no prior notice from the defense that it was forthcoming, and it was dropped in the Commonwealth 3 months after Mr. Ellington's prior report in this case. In the midst of this trial, how does it feel? And after the Commonwealth had rested its case in chief, Mr. Ellington now offers new opinions on entirely different issues that were not set forth in his prior report. To prevent further ambush of the Commonwealth by the defense in this case, he should not be permitted to testify to his new opinions. I'm sorry. Mr. Ellington now offers new opinions on entirely different issues. Okay. To prevent further ambush, he should not be able to testify to his new opinions. If he is allowed to do so, the Commonwealth hereby provides notice that it will present rebuttal testimony on those issues. Background. The defense previously disclosed to the Commonwealth a 13-page report from Mr. Ellington dated March 3rd, 2025. A copy of that prior report is attached here as Exhibit A. Essentially, the report quotes from or describes portions of the reports of Mr. Whiffen, Ms. Hyde, and Trooper Nicholas Guerno concerning certain data retrieved from Mr. O'Keefe's iPhone for the time period of January 28th through 29th, 2022, and then states whether Mr. Ellington agrees or disagrees with the analysis and findings of those other experts. Mr. Ellington's specific conclusions and opinions appear on page 9 through 12 of his report. His report does not address, much less offer, any opinions or analysis regarding either the data on the defendant's iPhone or any data on Mr. O'Keefe's iPhone after the time that the device came into the possession of law enforcement. Here we go. On June 1st, 2025, the defense produced to the Commonwealth a new 16-page report from Mr. Ellington dated the same day. A copy of this new report is attached as Exhibit B. In his, well, if she's going to start talking. In his new report, Mr. Ellington states that he was asked to focus specifically on activity and interactions logged on the two devices, that would be John's and Karen Reed's, after the times of seizure, surrender of the devices to the ultimate custody of the Massachusetts State Police.
All persons have any business before the Honorable Beverly Kinetic, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth.
Pause that for a second.
Court is now open. You may be seated.
Pause that for a second.
Good morning again, counsel. Good morning, jurors. So we appreciate.
Okay, I need to finish this. This is really important. Remember I was talking about GPS? Listen to this. After the times of the seizure, surrender of the devices to the ultimate custody of the Massachusetts State Police officers, including a review of GPS data points captured on the Reed phone. GPS on the Reed phone. Nowhere in the report does he explain why he was asked to perform this new analysis or when he received such direction from the defense. Nor does he offer any explanation for why this new analysis was not included in his report. Dude, homie put in a new report. So he did his report in March. Okay. I need to go back and start checking the dates of when I started putting out all this shit about a lot of the stuff that I had. Mr. Ellington did a new report and dropped it on their fucking faces on June 1st, focusing on John O'Keefe and Karen Reed's phones completely, with the data and everything to do with it after the supposedly law enforcement had it, specifically GPS data points. The Commonwealth is looking to be like excluding this. Accompanying his new report were several new spreadsheets of information that he created and that were not previously disclosed to the Commonwealth. On June 2nd, 2025, the defense provided a one-page amended to the June 1st, 2025 report clarifying a notification on John O'Keefe's cell phone. This is going to get fucking wild. Mr. Ellington now purports to discuss and opine on industry standard best practices for handling seized devices, investigate the timeline and circumstances surrounding the seizure and forensic imaging of the two iPhones by law enforcement, and conclude that, quote unquote, there is no evidence to support that the devices were handled properly by law enforcement, and thus allegedly there is and will always be a high level of uncertainty regarding the validity and accuracy of the O'Keefe and Reed mobile device data. It's going to get good. Okay, go ahead and press play. Yes, yes, yes. Belle, if you press play, please.
Your patience, we were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Okay, thank you. Can we have Dr. Voire, please?
Mr. Armand, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, Your Honor?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes.
You were shown this photograph last week, is that right?
Correct.
By Mr. Brennan, correct?
Correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes.
Under questioning by Mr. Brennan?
Yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court order.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
Dr. Voire, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we could have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Exhibit 219?
Permission to display?
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? You see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer likely from the pavement and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
What?
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
Damn. If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Dude, Dr. Welch would have got fucked up with his blue paint.
Permission to display?
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go up back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question.
Sure.
Jackson.
What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at?
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you.
I mean,
You
how
were
do you
asked
say
on
guilty?
Cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm? You can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Boom.
Do you recall what the weight of the hybrid 3 arm was exactly?
That's awesome, AJ.
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
Sustained. Ask the question. Stop striking the end.
Does 11.86 sound right?
Yes.
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
Bingo, percentages.
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes.
This is so embarrassing for
And what's
him.
the number?
23%.
Not 26%?
Sustained.
Is 23% smaller or larger than 26%?
Sustained. Let's move on from that, Mr. Jackson.
Why? I would just ask if 26 is 29. Is it the same number?
What is the number that you get if you were to divide 2.48 by 11.86?
.21.
In percentages.
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Approach all day, Mr. Jackson. Okay. Come on, bust it up, baby. Looks like we need a little sidebar. Little sidebar action. Let's give a little ringy ding ding. There you go, Hank. Hank can't math. We all knew that. Hank spent 400 grand. He doesn't give a shit. It ain't his money. You guys, how fucked up is that car? You guys, how fucked up? No wonder Welcher didn't run into himself. He knew he'd get fucked up. Dude, wait, the whole back glass shattered and came out of that. OMG. Oh, Tony got a bingo? Woo woo. I'll check it here in a second. Turtle Boy is agreeing to a bench trial. He doesn't want a jury trial. And he is back in the courtroom for Karen Reed. TV bench trial is at 11 a.m. He actually has a trial? Like trial? What's he on trial for? What's he on trial for? He waived his right to his... We'll get into all that later. Tony's going to start us off with a bingo. Well played there, Tony. Go ahead and scratch those cards. Meaning reset them, clear them all out. We got a second bingo starting up right now. And we're going to do a Bev is so lazy bingo. All you need is connect 4. You need 4 in a row. Bev is so lazy bingo. Connect 4. 4 in a row.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now?
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Cut the lights out.
Can we bring the lights back up and see if that's visible?
Can we bring the lights?
Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
Oh, fuck. Taking me back to school.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing? Remember those questions?
So watch the form, ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
No.
Sustained is to that point.
Does that make sense?
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay. Whatever's easiest.
Oh my God, this is hilarious.
If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared.
Correct.
Is 576.
They totally have a bromance. Oh my God.
Always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustained.
What's the first thing that you do in solving for this equation?
Hank is so jealous.
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
Just stop it.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38.
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5.
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
Basically nothing.
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
You just
what
showed
does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
More impact.
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm?
Sustained.
I love it. His argument failed. Hank, bye-bye.
And what was your
Goal.
opinion and conclusion as it pertained to the subject taillight using the 29-mile-an-hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29-mile-an-hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
Yeah. Okay, Hanky, what you got for us, Hank? Recross. You just need to stay within that, buddy. Look at him.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Duh.
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective.
Objection.
My specific question is.
So it's sustained. Ask the question differently.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where did your source to say that arm is validated for use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I don't have the percentage off the top of my head.
So if you take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay. Now when you have 216 pounds, 5.48%.
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8 or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Objection. Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just did the math, didn't we?
Yes.
Okay. And you used a calculator to help you, didn't you?
I did, yes.
Calculator works?
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
Didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
So ask the question.
Does the arm weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including
That's
the
not a
hand,
question.
forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier, is you would increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm, yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints?
No.
You didn't explain it to the jury that there's a difference in weight matters?
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggest or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Renfro. Can I finish, please?
No, objection.
Okay, so, no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions.
Bev, you cannot let people just get fucking ass raped up here. What the fuck, Bev?
Didn't you?
You have a duty, Bev.
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the
This is
jury
his
an
livelihood.
opinion
This isn't just about Karen
that the
Reed.
abrasions on
This is
Mr.
ridiculous.
O'Keefe's arm were inconsistent
Who the fuck does he think
with
he
your
is?
tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well,
Look at his
do you
face.
disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that. But I'm talking about the stiffness. Let's get back to the appropriateness
talk about the
of using a
stiffness.
crash test dummy.
I knew it was all
Now
coming.
conceding that a human that pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you
I used an
needed
8-inch
smaller
versus a 6-inch.
sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf?
Size of the shirt. Oh, God. How about the freaking Lexus? How about the damage to the Lexus? Can we just focus on that for a second?
And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones you use to test A and B, correct?
Correct.
the smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Medium.
Correct.
And then when you use Randy and brought him into the scene, you used the extra
Randy.
large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
Where'd he buy
We
that
used
from?
different sizes. The material blend was the same.
This was
Oh,
new.
it's not hoodie. They're getting free
Correct.
advertising.
The extra large you put on Randy was new.
Correct.
Did you consider that he
I wore it.
wear and tear on Mr. O'Keefe's sweatshirt? The extra large.
Did you consider if
sweatshirt
he was
wearing at the time?
that was freshly washed?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever
What?
consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever? Any type of
my God,
analysis
that's
whatsoever
loud.
on the age or whether it's
That
stretched
knows all about
the
a good
same,
dildo.
anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay.
This is amazing. People in NBC 10.
Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
Are cheering it on.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
Oh my God.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would it not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
Every single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
What?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
On what?
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair.
How is this not
You remember
outside?
writing in a report, it is significant to note that the injuries have been classified as abrasions, and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis.
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
Yeah, this has nothing to do with what he just asked.
Sustained.
Did you agree with that?
Sustained.
Did you write or endorse, these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm gonna see you at sidebar.
Did you hear Alan Jackson? Counsel, what are you fucking doing? This is so improper. This is ridiculous. He knows exactly what he's trying to do. Where the fuck is Paul? I mean, dude, I'm reading NBC 10 Boston's comments in the comment section. These people, whoever the fuck are in Boston 10's comment section, are absolutely fucking degenerates. Oh, yeah, Wolf's really getting exposed. Yeah, go, Brennan, get him. What? What? We were talking about this. Hey, so did you know, the shirt, was it comfy? Did it, you know how many times John probably washed that? And I think my shit tears more when it's run down because the thread's loosened. This is absurd. But people in here talking, I can't even read, these comments are crazy. Hank Brennan needed, I'm sorry, but he needs to get reprimanded in front of the jury, not over on the corner. Mommy pulls you to the bathroom to fucking put soap in your mouth. Hank Brennan, you're losing. You're getting fucked. How does the jury? They're going to be fine. Hey, look, this is so stupid. Look at the car. Look at John's face. Look at the back tail. Fuck the tail light. Look at the back of the Lexus. Out of here. Out of here. How do you even bring in a special prosecutor that's not even here, we're just going to bring this guy on. But he has no affiliation with the Norfolk District Attorney's Office. We're going to just bring in somebody else to go ahead and just do whatever. Hank doesn't have to worry about keeping his job or anything like that. This is insane. Paul was subpoenaed to TB trial. Good. Sit in there. Yeah. Hank just pulled a Mike Tyson biting Holyfield ear. I love it. Someone just wrote Hank needs handcuffs. Does Hank even have a partner? This is why all vehicles should have front and back cameras. Are you kidding me? No, how about just cops don't lie? How about people just don't set people up? How about Bev, you should have allowed Karen Reed to get all those fuckers' phones? Pisses me off. I'm still pissed that they were allowed to only call 2 cops, one of who didn't write a report and who wasn't even fucking doing dick in the case. Leaf blower motherfucker, and then Buchanan, and you think that that's enough to call to the stand in this type of a murder case, and they're gonna, and they're not allowed to call Easter to talk about how this is abnormal. No, I've never heard of a murder case where you call 2 police officers Unbelievable. Sick. I mean, Hank's just now throwing out, like, literally, he's throwing Hail Mary after Hail Mary. That's what's happening here. And I think Alan Jackson is like, put him on a leash. Did you hear him right there, though? It was objection, objection. Counselor. He's talking to Brennan. Counsel. Like, getting Brennan's, like, what are you doing? You want to know what's great, though, when you're an expert and you know that Alan Jackson, he's going to have your back. He's going to get up there and he's going to, you know, if you want to say rehabilitate, whatever. This guy doesn't need rehabilitating. He's badgering this guy. This is ridiculous. And Bev's, none of this shit is relevant. Oh, I can't help it if it's not my fault that Alan Jackson didn't think to ask Dr. Welcher what he was wearing and if it was brand new stuff. It's not my fault that Mr. Jackson, you know, isn't as smart as me to think about how you can, you know, blah, blah, blah. But he was saying a lesson or whatever. What kind of paint was that? What kind of paint did you use? Was it from the first grade elementary school right down the street? Like, where'd you get the paint from? Ridiculous. And I think it's embarrassing to like their field of what they're doing. Like, because like I said earlier, this has just nothing, aside from the Karen Reed case, what he's doing, Hank's trying to do to this expert, like, this field is needed, and you're like, good luck, Hank, that anybody is ever going to want to work with you. He's basically saying, Hank's basically saying that fuck all experts. And I'm not even just talking about like this jury. I'm not even talking about this case. I'm talking about in general, a lawyer. I think that's what Alan Jackson's probably like going ham about. This isn't just this case, Your Honor.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point.
Drag the
What I'm asking
arm.
is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained.
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
What?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Exactly.
Drag. Push.
Dragged.
We'll use the word push. Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Oh, no. You said it moved the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
What?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity?
The operative word here is push. And so do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Oh.
Yes.
We just watched the demo.
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle?
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used
They're
by firefighters
$150,000?
and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
Oh my God.
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yeah.
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection. Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
The clothing that was missing
that
for
down.
days. I think you just opened the door.
When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained, it sounds like it's beyond the scope.
Very well.
Yes, it is beyond the scope. Thank you.
When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talking about the hand?
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Beyond the scope, Mr. Bowman.
Thank you.
A few more questions, Dr. Wolf.
Shut the fuck up, Hank.
You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
What?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, You have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor.
If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked to give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
So that's sustained as to form.
How?
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Yes.
Correct.
Do you have any idea the size of those pieces
Nope.
as you sit here?
Not without a scale of some sort,
Yep.
no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No
Microscopic.
idea if they're a foot long?
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know. He was
That's
asked questions,
the
Your
end
Honor.
of that, Mr. Jackson.
What? Okay, sidebar.
Do you have Mr. Wolk, do you have the picture of the tin? The TIN, tin, the little round tin?
Oh yeah, show the scale of
You
that.
see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
And it's a scale on it.
I do recall seeing, yes, in the evidence photographs of all of the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
Whatever, Bev. What are you talking about?
You were asked a question
Good job, AJ.
about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
The objection sustained and it's struck.
Why?
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
You already have follow-up questions.
Okay, go ahead.
Come on, man. Okay, go ahead, Hanky. Sure, I'm gonna. And that was like, God. What are they doing now? Sidebar? Sidebar. Sidebar, Bev. Ridiculous. Ridiculous. Moronic is more like it. Destroyed, just like yo dick, Brennan. Destroyed. Like your wife's panties when she ain't hanging out with you. Lana, that is so inappropriate. His line of questioning is so inappropriate. What's the sidebar for? Oh, Lord. Make sure you guys make yourself known. Hit the thumbs up. Hit the thumbs down. You're here for a reason, though, right? Lord knows. Lord knows. Lord knows. What's going on over there? What's up? What's up?
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, I'd like the source.
No.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it, strike the source.
Do you agree with that?
Dr.
I'm sorry, can you
Rentschler,
repeat
what?
that?
His name's Dr.
If you have
what?
an arm
Wolf.
that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Do you agree with that?
I'm going to allow it.
I need to approach.
Love it. AJ ain't taking no shit. He's like, we need to approach. I need to approach. Like, yes. He's like, we can just sit here and do this all day. We just went through this. We just went through this. What's going on here? Okay. Like, I want to know how the jury is feeling about this. Like, they already have to have an opinion about it. And there's just one of two things. You're either on the opinion of, we'll even give it 3 columns. Column 1 is, do you think that the SUV caused the damage? Column 2, the SUV did not cause the damage. Or number 3 column is, I don't know if it caused the damage. Okay, that's in all 3 testing. Well, how about this, Hank? How about this? Why did your people perform a test? Why did your people perform a test? Oh, that's right, because they say that it's really hard to reenact crashes like that because so many things could happen, right? Well, how about this? We'll allow you to have 100 tests. Continue to do it until you can find one of the tests that you recorded that shows consistency with what John O'Keefe looked like, the Lexus looked like, and where these particles were. I stand by my test is all I would say. I stand by my
One more
test.
time, okay?
Right there.
Okay.
It's right there.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward
and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like it says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take our morning recess. We'll see you in about 20 minutes.
Who needs a 20-minute recess and then you're about to get an hour lunch? 20-minute recess. I mean, maybe they only have one bathroom, so you have to give 1 minute for everybody to use the bathroom, so that's where they get the 20 minutes from. Bev, you're absolutely ridiculous. Let's look at something here. So this is how I would be doing it in the jury deliberating room. I would make a chart that would look like column 1, 2, 3, and 1 being that yes, it's consistent, 2 is no, and 3 is I don't know. But the rows would be let's just look at the SUV. Oh, here we go. What's going on?
All right, so we're not going to do the voir dire right now of Dr. Lapisada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Lapisada? Is that you, Mr. Jackson? Yes. All right, so what I would ask you to do is not do anything on your direct examination with Dr. Lapisada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire, but I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you?
I don't think Rensselaer's being called.
Use the hour?
Thank you for the credentials, but Your Honor, half of the credentials are the fact that she's an expert in dog bites and an expert in motor vehicle. I can give her education, training, background.
Okay, is that all in her resume?
It's all in her, it's all going to be in her direct examination.
No, my question is it in her resume? Has the Commonwealth received notice regarding the dog bites?
What?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says the word dog bites anywhere. No.
We have absolutely no notice.
But the courses that reference dog bites are listed.
Say that again?
The courses that reference her teaching dog bite issue and pattern recognition, they're listed in the resume.
All right, we'll see you at 12.
Is Dr. Rensselaer going to be next? Oh my God. Okay. So then you have a column that would have the SUV by itself. Look at the SUV. How many people, like, regardless, is the SUV consistent with the damage that you would expect? Striking. Yeah, only if you hit the arm, the back didn't come out. But is the tail light, I mean, it's not, all of the tail light's not gone though. So you would answer that question by saying, yes, you can damage the headlight, but then you would be like, but no, because the damage to John O'Keefe is not consistent. Or you could say, I don't know, because I think that all of these tests were, there's like something wrong with every test. Fucking A, end of the day, whatever. End of the day, you have to say, I don't know. I don't know what's reasonable about. I think it's reasonable that didn't happen. So when I was looking over these documents, the defendant's motion for reconsideration of the court's March 31st, 2025 order excluding the testimony of defense expert Michael Easter, they are excluding him, but they wanted her to reconsider. And so I went through this again because I was just like, how in the world is Bev going to get away with this? Okay. Why can't they call somebody why aren't they allowed to call somebody as part of the Bowden defense that would be testifying that this is not a normal investigation, like this is not best practice. This is what you would have done. This is what you would have done. This is what you would have done. Because over the course of 2 days on May 5th and May 6th, Lieutenant Gallagher testified to his account regarding evidence collection outside of 34 Fairview Road. Lieutenant Gallagher stated that he used a leaf blower to clear the area and uncover crime scene evidence, a method ripe with a substantial risk of disrupting or destroying evidence. Was proper and effective in this instance. He's saying that he thought it was the greatest thing since sliced bread. Okay. Further, he testified that because of the weather, it simply would have been impossible to follow protocols. Finally, Lieutenant Gallagher admitted that he chose not to search the home adjacent to the crime scene, owned by a fellow officer, falsely claiming lack of probable cause, and that it would be improper for him to attempt to obtain consent. That testimony was incredibly misleading, and there is a significant risk that jurors will give his testimony undue weight, merely because he is a law enforcement officer and lay witnesses are unfamiliar with the legal standards attendant to criminal cases. Absolutely. Absolutely. Trooper Yuri testified over the course of 3 days on May 8th, 9th, and 12th regarding his involvement in the investigation and asserted that this investigation was conducted with honesty and integrity. The defense is entitled to rebut his self-serving claims. Trooper Buchanan admitted that he never entered the house at 34 Fairview Road to search for evidence, interview witnesses, or to photograph the home at 34 Fairview Road on January 29, 2022. Further, Trooper Buchanan failed to explain how he deviated from the normal chain of custody protocols, noting that while certain evidence was discovered on February 3rd, 4th, and 10th of 2022, it was not written in a report until November 4th, 2023, almost 18 months later. He also fails to offer an explanation for failing to interview two potential witnesses, Ricky Dionato and Heather Maxson, who were at 34 Fairview until over a year later. Furthermore, Trooper Buchanan admitted that there was evidence logged that he himself turned over where he could not identify who eventually filled out the evidence label. Like, how the fuck do you not allow this? He claimed that there was nothing unusual with the handling of the evidence in this case. Proper chain of custody protocols are quote-unquote not common sense issues that are apparent to lay persons. The defendant is entitled to call an expert witness to testify regarding proper chain of custody protocols. The investigation in this case was clearly inadequate and deviated from standard policies and protocols. The defense is entitled to call an expert witness to establish that this case did not conform to standard or accepted protocols. The Commonwealth therefore opened the door to testimony by a qualified expert who can clarify for the jury what those protocols actually are and why these departures matter. I mean, this is huge for Karen Reed's defense. Just as jurors are routinely aided by expert testimony, police regularly testify about information for which specialized knowledge would be useful, even if the information could be general knowledge for a certain juror. Thus, Ms. Reed should be permitted to proffer testimony from a seasoned FBI agent regarding investigative principles, policies, and professional standards. Michael Easter's testimony, rooted in the Massachusetts State Police Policy and Procedure Manual and decades of experience, falls well within this permissible scope. I know it's already been denied. I want to say on the record that this should have not been denied. And this is clear error to not allow it. How do you get away with presenting to a jury just two cops? The defense's right to present a Bowden expert has now become essential to ensure a fair trial. In Commonwealth v. Wood, the SJC explicitly upheld the right of a defendant to call a forensic expert to challenge the adequacy of an investigation. The court emphasized that the jury had the benefit of 1, cross-examination, 2, closing argument, and 3, the calling of its own expert as part of the Bowden defense. That trifecta is precisely what the defense seeks to employ here. And the removal of one of those legs unjustifiably undermines the defense's constitutional right to present a complete defense. What is Bev thinking? I mean, really, truly, what is Bev thinking? Because Bev doesn't give a fuck if she's overruled. Even if jurors may intuitively recognize some investigative irregularities, they are not equipped to assess whether those actions violate coded procedures, create contamination risks, or reflect investigatory bias. The argument that a lay juror can adequately gauge the seriousness of Lieutenant Gallagher's use of a leaf blower or Trooper Buchnick's failure to appropriately comply with the chain of custody protocols without the aid. Now, right here, because of what he just elicited out of, I believe, they need to write this motion up again and put in there because of Hank's bringing up John O'Keefe's clothing again, okay, to Dr. Wolf. I believe that you reopened the door, okay, as to now we have chain of custody issues, which we've had before about the clothing, okay, and you just asked Dr. Wolf about the clothing and why it doesn't have things. Well, the clothing was just... The clothing is fucked because it wasn't properly preserved. So Michael Easter should be allowed to testify even before this reopening of the door, I believe. Anyways, that's my take on that, is that Hank then just got to I just feel like Hank got a free fucking pass to talk about the clothes and at no expense of hey, he just talked about the clothes again. Hello. So, next, what else did I want to talk about? I want to talk about, missing witness argument. So, defendant's motion to present a missing witness argument and request for subsequent instructions. This is Karen Reed basically saying that we have issues because of 3 missing witnesses. Now comes the defense, Karen Reed, and respectfully moves this honorable court to allow for the use of a missing witness argument and subsequent instruction in her defense. All foundational requirements for a missing witness argument and instruction are met. Allowing Ms. Reed to present a missing witness argument would best position the jury to consider all of the evidence at issue, including what is missing from the Commonwealth's case in their deliberations. Basically, this is an instruction that you can take a negative inference of Proctor not testifying, Brian Higgins not being called, and Brian Albert not being called. So the Commonwealth's position is that it is appropriate for the court to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward who is friendly to or at least not hostile opposed toward the party and who can be expected to give testimony of distinct importance to the case. The party would naturally offer that person as a witness. If then, without explanation, a party does not call the witness to offer testimony, the jury may infer that the prospective witness would have given testimony unfavorable to that party. The underlying premises of a missing witness instruction is that a party's failure to call a prospective witness raises a reasonable inference that the witness would have provided testimony adverse to that party, and a jury should be afforded the opportunity to consider that information in their deliberations if they deem it to be reasonable. A trial judge has discretion to refuse to give a missing witness instruction requested by either party. However, cases supporting the need for judicial caution in permitting an adverse inference are an opposite when the inference is to run against the Commonwealth, because there are no constitutional concerns to warrant the call for the caution in such instances. Again, they're citing cases. Michael Proctor, Brian Albert, and Brian Higgins are all available and friendly to the Commonwealth. So basic to inference is the existence of evidence of physical ability of the witness and the likelihood that that can be produced by summons or otherwise. Michael Proctor, Brian Albert, and Brian Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these 3 witnesses. Additionally, the defense is informed that Brian Albert and Brian Higgins were both under subpoena by the Commonwealth. Michael Proctor, so that means Michael Proctor was never even in the consideration. Michael Proctor, Brian Albert, and Brian Higgins are all friendly to the Commonwealth. All 3 witnesses testified cooperatively in the 2024 proceeding as witnesses in the Commonwealth's case. There is no reason to believe that these individuals would not continue to cooperate with the Commonwealth as quote-unquote friendly witnesses less than a year after their prior testimony. Additionally, the fact that Ms. Reed could call these 3 witnesses does not render the adverse inference impermissible, because the Commonwealth is more acquainted with these witnesses and would be naturally expected to call them in establishing their case in chief. A missing witness instruction may be properly given where the prospective witness is more friendly to one side than the other, even if the witness was unavailable to the party requesting the instruction. Michael Proctor, Brian Albert, and Brian Higgins each would be expected to give non-cumulative testimony of distinct importance to the case. Yeah, what's up? What's up? Michael Proctor's anticipated testimony would not be duplicative of other witnesses called by the Commonwealth. Testimony from the lead investigator in this case is of great importance to this case, as the role is inherently unique compared to other witnesses, both civilian and law enforcement, put forth by the Commonwealth. Michael Proctor was the lead investigator and was responsible for recovering a significant amount of the evidence in this case. So they're asking for a jury instruction. that you are allowed, jurors to think and to hold it against the Commonwealth and think negatively as to why they did not call Brian Albert, Brian Higgins, and Michael Proctor. Moreover, Sergeant Buchanan's testimony confirmed that nearly every piece of evidence recovered in connection with this case, including all the taillight pieces recovered at the scene, Mr. O'Keefe's clothing, Mr. O'Keefe's cell phone, and the surveillance video from the Canton Police Department were in Michael Proctor's sole possession for months or years before they were booked into evidence. That is absolutely unfucking believable. And this case shouldn't be allowed to be tried due to that. How is this case being tried? Similarly, neither Brian Albert nor Brian Higgins anticipated testimony would be duplicative of other witnesses called by the Commonwealth and are each central to the case. No one, except for Brian Albert or Brian Higgins themselves, can testify to their exact whereabouts within the home at 34 Fairview on January 28th and 29th. Sarah Levinson and Jennifer McCabe's testimony are not suffice to support the claim that John O'Keefe never entered the curtilage of 34 Fairview, as they were not all together the entire time they were at 34 Fairview, leaving Brian Albert and Brian Higgins each with the opportunity to interact with John O'Keefe within the curtilage of the home without any other witnesses being aware. Ding, 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 ding. That's what I've been saying. Ding, ding, ding. Good afternoon, everybody. Is it almost afternoon? It's technically 12 o'clock on the dot. Get your ass back in here, Bev. Specifically, no other witness has testified thus far or even would be able to testify to and be meaningfully cross-examined about the reasons for Brian Higgins visiting the Canton Police Department around 1:30 a.m. Additionally, no other witness has testified thus far or even would be able to testify to and be meaningfully cross-examined about the reasons why Brian Albert, a trained first responder, and his wife did not come outside around 6 a.m. on January 29, 2022, when their bedroom was mere feet from the scene of drastic life-saving efforts by paramedics and firefighters, response by police officers and their respective cruisers with lights, and the sounds of three women discovering a loved one unresponsive in the snow. There is no logical or tactical explanation for the failure of the Commonwealth to call Michael Proctor, Brian Albert, or Brian Higgins. If the Commonwealth provides Your Honor an explanation for not calling an available witness, and that explanation is suffice, the missing witness instruction can be properly rejected. An explanation is suffice when the trial judge is satisfied that the circumstances thus offered would, in ordinary logic and experience, furnish a plausible reason for non-production. Here, the Commonwealth has not and cannot provide a suffice explanation for not calling Michael Proctor, Brian Albert, or Brian Higgins. The Commonwealth understands the risk that the testimony of these three witnesses poses for their case, as all three are highly susceptible to impeachment on relevant and non-collateral issues. The Commonwealth is choosing to obscure and hide from the jury the complete picture of what occurred at 34 Fairview Road on January 28th and 29th. All three of these witnesses are susceptible to cross-examination regarding issues that are central to this case. One, Proctor's handling of the investigation and relationship with the very witness who should have been suspects in this case. 2, prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview Road for a period of time in the early morning of January 29, 2022 to look at photographs in some other part of the house. And then 3, 4, 5, and 6 were all redacted. And so the belief, I believe now that the defense is going with is that everything went down in the garage. So depriving Ms. Reed of the opportunity to present a missing witness argument and denying giving the instructions would undercut her ability to present a defense. A significant portion of Ms. Reed's defense has been focused on the inadequacies of the investigation into the death of John O'Keefe and a lack of consideration of other suspects. A judge is required not to take the issue of adequacy of the police investigation away from the jury. Dude, she would do that 2 times if she's not letting Michael Easter testify and if she doesn't give the jury instructions. You understand how crazy that is? Ms. Reed, not affording Ms. Reed the opportunity to argue that the jury should draw adverse inferences from missing witnesses in the Commonwealth's case that are deeply involved in the investigation itself would erroneously remove from the jury's consideration the precious issues sought to be raised by the defendant. This jury should be provided with the necessary framework for considering the absence of evidence or witnesses should they deem it relevant information to their deliberations and assesses the weight and significance of the missing evidence or witness in relation to the evidence presented against the defendant. This was asked on by the defense June 2nd. It was put in. I was comparing now the jury instructions that were both the defense put in, and I'm going to do a live about it to put them side by side. But the defense put in like a 35-page jury instruction, and the Commonwealth put in a 17-page, pretty much jury instruction. And so now I'm going through them to see like what the big differences are in terms of and then these are the whatever she decides on that's, whatever she says out loud, they then take it into the, deliberating room with them, like the written instructions. And so it'll be interesting. Oh, there we go. Perfect timing, Bev. Welcome back.
All right, so I'm told counsel wanted to see me.
Has arisen related to the cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness? Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Alessi?
Bear with me a moment, Your Honor. I need to put on evidence gloves.
I need to put on evidence gloves. Oh, God. Alessi, what you got for us? Is everybody back? Everybody good? Everybody can hear?
Lana, can you hear me?
Yeah. Oh.
Shirt out of the plexiglass.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked the first document, and I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
You guys can hear me, right? Okay. Okay, now I can see you guys. I have 2 devices. Thank you.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is
Oh
in
my
fact
God,
the
there's
case,
no
Your
holes
Honor.
in the sweatshirt? It's fucking over! It is over! Oh my
I can't
God!
tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Oh my God!
Thank you, Your Honor, thank you, Madam Court.
Oh my God, it's gonna be over! Oh my God!
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely, Your
Mr.
Honor.
Leslie.
So, here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist, and I'm going to get to back to this in a moment. but I would like to do it and certainly entertain any of Your Honor's questions, but in a logical order.
Sure. So I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
Oh my God, with the jurors and lunch. This is about someone's life.
All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-21884. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I
This
can
is
conduct my
wild.
argument from right here, if that helps, Your
I
Honor.
just want to see, point out to me where it says, where it shows the back.
Oh my God.
You can see the back of the hoodie, that's the back.
Hanky!
Hoodie head.
Hank, you threw your case. I don't know if he threw his case.
Let me just get a check on this, Your Honor.
This is absolute fucking amazingness. It's over.
Mr. Brennan, you should come up and look at this.
And I'm
It is absolutely over.
So this is why.
It's over. There ain't no coming back from this. He's gonna say, I just made a mistake.
Can I get the check? Pardon me?
The label cut.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing, Mr. Bond? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, just a second. It may have printed the wrong page. I can do it, but Mr. Wolf, can you print the back? And Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
I understood. We will. He's printing it right now.
See, I said the same thing. I want to have a printer at my desk table up there. Yep, perfect. They can do it. I want to know if it was improper. It's definitely not improper. Boom. Great to know. He's got a laser jet back there. Oh, that's titties.
We printed. We wanted to have the front and the back show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
We have a bingo. Congratulations, bingo. This is, yeah, you want it with prejudice. That means they can never recharge you. Without prejudice is when they can refile. This is, it's over. Congratulations, Stacy. Shake it. I got it for you.
So I may, Your Honor, I'm advised it'll take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor.
Oh, did he have to leave the? He had to leave the. See, he doesn't even. We're not even.
So,
well
Your Honor,
equipped
what
with
is
that.
being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that,
we want the
Your Honor.
mistrial.
And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it get marked so I can then refer to it.
All right.
Thank you.
Can we print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
He shouldn't be talking about anything to do with what you want to tell the jury. We're not telling the jury shit. This is an automatic mistrial. Hank, what do you need to see? You don't know what the hell took place here?
Sure. And here's another document, chain of custody document.
There is no salvaging this. It doesn't matter, even if she, like, it's, Karen will win on this alone. This is 100% a mistrial and an appeal if she doesn't grant it.
Well, Mr. Brennan is reviewing that. If I may hand to Madam Court Reporter the chain of custody document for these, and that he marked is the next exhibit in order.
Okay.
And then, with Your Honor's permission, I would.
Did you see how fast she wanted to just say?
Your Honor, so Your Honor can see what I'm referencing.
Thank you.
You know how fast Bev was like, okay, yeah, no, I agree. I can give them a jury. That means that you understand what's going on here. Don't play fucking stupid. You understand what he's saying. If you're just like, I'm gonna give him a jury instruction. No, fuck you. We don't know jury instruction. It's over. This is the grounds for a mistrial.
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
Okay. So if I could have one set, that would be great.
And she's gonna have to go back in her chambers.
Thank you.
I still do not have ZZZ.
I still not have VVV.
The best part about this is they're preserving the record.
Yeah, that's a given because we're gonna. But this is way.
Okay, go ahead, Mr. Leslie.
This is way worse than the Alec Baldwin bullshit.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology.
Mm-hmm.
And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that
it's misconduct.
What just happened, and I'm not going to repeat or go into other than to reference, this comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
that's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case.
It's over.
We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some
It was a plan all along. It was a plan all along.
These are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional.
Yep.
That it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice.
Yes, it does.
The amount of effort, the amount of work,
callous,
I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense.
Yeah, fuck no.
That should befall the prosecution. Ms. Reed, again, is entitled, like
to a fair trial.
Every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
Yes!
All right, thank you. Mr. Brennan.
What are you going to say, buddy? Record this shit.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right.
No, it's over.
So I'm not going to allow the mistrial motion, Mr. Lessie. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence.
This is fucking insane!
They can be displayed for the jury. And I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something
Regardless,
like
it doesn't matter. It's over. Doesn't matter what Bev
I
says.
instruct you, you are not permitted to draw
Karen,
any inference.
This will be turned in like
these
2
could
seconds.
have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please?
I would do, I would do an interlocutory
It's unclear
appeal
for me.
right now.
Do you have a better idea, Mr. Lessie, what day these were done? Is it all of those 3 days? Now I see a 4th day.
Motion for,
5/11, no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates.
Your Honor, on or about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor,
What?
I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instructions for Your Honor.
So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to 2 things. One, I would like the opportunity to have the hoodie sweatshirt held up. Because that's what
Okay.
happened.
Yes.
It is-
Yes.
These holes in the
Yes.
back-
Yes.
Okay, thank you.
So that's number one as part of the stipulation, and then.
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of it.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference.
I'm so sick of that. Like, anybody that donates to fucking the Commonwealth is a bunch of fucking idiots.
Of the events on January 29th, 20.
I'm just so glad it's on national television.
So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
If you're not going to listen to it, who the fuck do you think you're talking to, Bev?
Okay. All right. So it's what I said, Mr. Lessie. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should.
This isn't what the United States justice system is built on.
They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf.
No, we want what the fucking, what those holes
I instruct you
are.
that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
We want the jury to know that Hank.
Just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but the.
Oh, fucking stop looking at your watch, Bev. Jesus Christ.
We don't need to do that right this second.
You are late every single fucking day. And you're looking at your watch. That shit's broke.
Thank you.
I'm so sick and tired of this fucking frumpy bitch.
All right, thank you.
I mean, who can literally be watching this as a prosecutor and be like, yeah, this is normal? If any prosecutor in America was watching this right now and saw
Mr.
this,
Lessie, you're simply going to stand and hold the sweatshirt, right?
they would say, I would lose my job. I'm out. This is so, you know your case. But see, they.
In Your Honor, I would hold it as Your Honor begins to read. Is that consistent with Your Honor's expectation?
No, I want you to hold it up with the back.
Would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
Bullshit.
All right, so Mr. Lessie, why don't you where are you going to stand?
This isn't a mistake.
Where are you going to stand?
I want a ruling on if you think it was a mistake. Do you think he was deceiving?
All right. So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer.
Yes, court officer.
I think that they need to take more time in presenting their
Then we will
mistrials.
take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here. She's on next. We're going to call John T.
For just the measurements?
Go ahead.
told you that Lapisada's next. Why are you guys messing with me?
Your Honor, if I would be able to show the exhibits from Ms. Hartnett where the cuts, along with the next after the strike, show the cuts were made by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are, so.
This is the biggest shit show I've ever fucking seen in my life. I think the Idaho 4 case is going to be just like it. And I'm going to be there for it every step of the way. Why do we have rules? Why do we have rules? This isn't a mistake. You didn't order a cheeseburger and you meant to order fucking chicken fingers, motherfuckers. This isn't a mistake. This was, and I just know they need to take more time with presenting this because this was calculated.
Jurors, I appreciate your patience. Mr. Lessie, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag?
Look at Hank.
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll, Mr. Yannetti, your next witness, please.
Wait, that's it? That's it. She's going to give more tomorrow morning. Get the fuck out of here. Absolutely no way. I want to see all those Hank lovers suck him off after that one.
Tell me the evidence you give to the court and jury in the case now is here to the truth, the whole truth, and nothing but the truth, so help you God. I did. Thank you.
Pathetic if somebody like that represented me.
Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's T-E-D-E-M-A-N.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location, sorry.
I started out in Los Angeles and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
Can you describe what a wheeled measuring device is?
Yeah, it's like a handle with 2 wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
Okay. And if we could, Mr. Wolk, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolk? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down, Mr. Wolk, and put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the 2 car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Heard on what? Heard on what? Heard on what? Can I be heard? I'd like to be heard on that. Because this is so prejudicial for us to see some fucking photos, right? Of the house. It's so prejudicial. To what? To what? It's the fucking pictures of the house. How is that prejudicial? Oh, because this is like a couple years later. Oh, but John keeps buffed out, waxed up, traverse rolling on dubs, all shiny. It ain't prejudicial. Fuck outta here. Prejudicial. Cannot believe that she has the fucking cahoons to fucking act like she can say I can't even. But you guys, I know it all too well. They don't. You want to talk about people that think that they're above the law? Prosecutors, judges, and police officers. That is the trifecta, motherfucker. So, note to self, don't marry a cop, don't marry a judge, and do not marry a prosecutor. Your life, if you do not stay married, will be a living fucking hell. We the people. How can anybody watch this and be like, again, who cares if Karen Reed's innocent? Who cares if Karen Reed's guilty? How can anybody watch this and say, wow, wow. It's called, the words are an unfair trial. Hang Brennan isn't about presenting to the jury, here's all the facts. Now, jury, you decide. No, it's here, I'm going to tell you what happened, and I'm going to shove all this false shit up your ass, and then you're going to spit it out with a guilty verdict. I'm going to shove up your ass, and you're going to spit out your mouth. Someone says, LOL, I'm divorced to a cop. I bet you feel me on that. Ridiculous. Absolutely ridiculous. Ridic. This is not, like nobody, there's no arguing. This is not a fair trial. This is not impartial. This is not fair. And that's what you are afforded. And these are violating our civil rights. We are watching all of our rights be violated. Not just Karen Reed's. What don't you fucking people get? This isn't about Karen Reed. This is about all of us. We are literally, they have the audacity on live national television to fuck us. What do you think they do when no one's watching? Oh, let's just be so on the up and up. It's worse. I hate the word discretion. Can you imagine if a referee in a fucking sporting event had discretion? Like, there's rules, right? A travel is a travel. Discretion.
That was a good way of putting it, Lana.
Fucking A out of here. Thanks, Bella. Appreciate your kind words.
I think we might be back.
Discretion. Who the fuck? What do you mean I have discretion? Discretion because why? What are you seeing that's going to give you discretion to go the other way? Or are you deviating from a worksheet? Who the fuck made these rules up that we should just allow discretion?
Okay, Mr. Wolk, whenever you're ready, if you can display that portion.
Because everyone has a different way of interpreting the rules, I guess. Bullshit. Karen was framed, period. and then we're watching a framed woman and our rights get, I mean, you want to talk about getting it stuck up the ass? Beverly Canone is sticking it up Americans' asshole.
So I'm going to ask you to take that down.
I'm
Folks,
going
we're
to ask
going
you
to
to
take
shut the
the
fuck
luncheon
up,
break at this
Bev.
point, okay?
I am so sick of this shit. I'm going to ask you to take that down. I'm going to ask you to take off your pants. I mean, this is ridiculous. I'm going to ask you to take that down. I'm going to ask you to touch your toes. Simon says, Bev says. People watching this. And then you have people on NBC 10, Law and Crime, cheering on Hank. And it's those people that I hope get a speeding ticket today for going 1 mile an hour over the speed limit. That's what I wish for you.
All right, so we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right, so can we get Dr. Lapisada in here? We'll do a very brief voir dire of her.
Where do you have to go, Bev? What do you have to do? I mean, do you have to go do some... Does she have to go do some misdemeanor cases? I mean, why are we rushing through a murder trial?
She has to do her Kegels for her DP. Double penetration.
I just think that like America's watching her and she just doesn't give a shit. That's it. You know what? I am calling I'm calling the courts right now. And I'm going to say, this is my name, this is my number. Fuck all you motherfuckers. What are you going to do? Come arrest me? Because I said, fuck you? Well, you can't. This makes me sick. That is defense witness number 9, Lana.
I do.
All right, good afternoon, doctor.
Good afternoon, Your
They're
Honor.
like, thank God we didn't watch Lana during
Voire,
Miss
okay?
Dever.
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
I'll allow it. Wait. The jury's like, what just happened in there, you guys? The prosecutor just totally lied to us as we're eating our ham
Your Honor, for
sandwiches.
purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those 2 areas. And if there is support or methodology in Dr. Lapisada's resume to point to exactly where that is, okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Lapisada. That's spelled Laposata.
Dr. Lapisada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Lapisada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner of death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
God,
yes, I
she's
did.
so cute.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At
medical
the
school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at the hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction consumption?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Go get him, baby girl.
Good afternoon, Dr. Lapisada.
Good afternoon.
Put it in his mouth. Put your titty in his mouth, baby girl. Just do it.
Dog bites.
Yes.
Pop it.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, starting in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, yes.
And
I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapisada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on this
in your report
case?
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
They're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around, I look at the body, I look at blood stain patterns, I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you've been qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Lapisada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lapisada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
No.
All right. You are all set. I'm going to ask you to step down, Dr. Lapisada. We'll get to you sometime this afternoon.
Okay, thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Easily, yes. Your Honor, I'll make this very brief.
Okay.
Dr. Lapisada
Is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk, well, she's called to talk about several other subjects, but these 2 subjects that's before the bench